we're going on vacation in 2 weeks. Almost slipped up and said it. Almost said it. Nope, not getting out of me. But you guys, we have vacation in 2 weeks. Don't forget, make sure you guys are packed and ready. Scotty! 30 days sober today. Congratulations. That is amazing. If you guys all show some love for Scotty Joy in the chat as well. 30 days sober. That's me. No. That's going to get me. Brittany, I have no idea. Almost got it lit. I stopped myself quick. But this will be needed there. It's actually one of those like makeup fans. And it works good to stop my eyes from watering. Brie has some new infos that came out. What was the 711 pieces though? For who was that for? What is telling me to charge? Well, who's yelling? Oh, my Bluetooth. Shut up, lady. I was done with you anyways. It is so freaking hot, you guys. Oh, for you. I was like, wait, what? I haven't seen any of that. 3 years ago. And she said, wow, that's crazy, Alexis. Well, I'm glad you got all 711 pieces. You need to go get you a Slurpee. Go to 7-Eleven and get you a big old Slurpee. Okay? That's what you need. It's okay. No, well, listen, just whenever you have time, okay? Because there'll be sometimes I may be doing an activity at nighttime. I may pop on and share, just like when I was on vacation last time and I went and did activities and stuff, and I would go live just to kind of show you that we wouldn't really talk about anything. Just kind of, do whatever. That's what I do. Hi, Lolita. Right. And I don't know what it is because you guys know I never look at the filings beforehand. You guys, I am so hot. The baby is still sick, and so she took a nap with the humidifier and she slept late because she was finally able to breathe. Hi, Always a Forever. I was like, why am I sweating so much? The fucking thing was set at 80 degrees. It was just blowing hot mist on me for 2.5 hours. I'm about to die. It's cool here too. I mean, it's not that cool. I think it's like 40 degrees or something. So, I mean, to me, that's warm. That's not even using the heat weather. But -10 tonight. Yeah, it's just from being in the room with her for a couple hours with 80-degree mist blowing on me. Okay, so let's talk about a few things before we get into the court docs. Did you guys hear? They always talk trash. That's all they have to do is talk trash. Those two yahoos. Hey, Heather. Pup Mom says, it's warm today at 7 degrees. More court docs. Yeah. I double checked. It's only 4 pages. Almost didn't go live today. And then I checked my email. Walk like an Egyptian. Look at my eyebrows. Oh my God, that's so cool. Walk like an Egyptian. Thank you, love. Tiana. Hello, love. Time for more lotion. Anyways, did you guys see that Anti put up a thing? Someone asked how did baby sleep last night? He says, great. Put her to bed at 9 o'clock. She slept straight through 9 o'clock till like 6:30 or 7 o'clock in the morning. See what happens when you let the baby out of the pack and play? And the baby gets to roam around and get all that exercise out? Thank you for making an account to come in and say that, you dumb twat suckle. Anyways, I love how people are just, the maturity level here is ridiculous. When you let the baby out of the cage and you let them roam around and you have a schedule, it sticks. I don't know that she doesn't let her play. I'm just saying she's on live a lot, and the only time she shows the baby, well, not the only time, about 90% of the time she shows the baby and the dog are in a pack and play. The baby, the dog, and an iPad are in the pack and play in a whole nother room in the dark. That baby was having a heyday. Roman. Hey, we're just Roman. Having a good old time. Yeah. But if mom isn't following the schedule, right, it's not going to work. It's going to go right back to being how she is over at mom's house, and then back to being good with dad. It's going to end up, though, if it continues, he's going to have enough evidence to be able to go back and file for full custody. And again, that's not what I want. I never want that. I think both parents should have equal access, so I'm not rooting for that. I'm not saying that I want that to happen, but I'm saying that that's going to happen if she continues to just be on live 12, 14 hours a day and the baby just in a pack and play. Nothing right now. I'll be start reading them here in just a little bit. To shop, then got bombarded with horrible teen parents. Wait, what? I downloaded TikTok to shop, then got bombarded with horrible teen parents. Oh my gosh. Right now we're just kind of talking about random stuff. But I was just talking about how Anti was able to put the baby to bed at 9 o'clock. Hey, Chris. And she slept through the night till 6:30 or 7 o'clock this morning. Amazing. Yeah, they just act like teen parents. Hi, Walking Karma. You know who else I want to talk about who is not a teen parent or even a Betty or even a young parent, but is a horrible parent? Hi, Stephanie. And Ashley. I thought we got rid of Ashley. How is she coming back? Why is she back over here? Yeah, well, yeah, she's a terrible one too. Ashley is so... Thank you, Sherry. Look at the butterfly. Ashley, I have no idea. That's KK. That's my question. Why is she back? Why is her Oompa Loompa ass back? No, we don't miss anything. We just started. Trashly Ashley, Ash Torino. She is so obsessed with Fester's ex-wife. Honey, a wife, okay? She owns the house that your ass is in right now. Let's just get that straight. They sit on live and they go all day. And she's talking about what a horrible mom because she gardens. Bitch, your kids don't live with you. They live on a porch without beds and you were just arrested for welfare fraud. Talking about how your Louis and your Chanels and blah, 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 blah. And you're on scamming the system for welfare fraud. Yeah, Chloe, I guess they turned their outdoor porch into a bedroom somehow. It's not like, I don't know. I asked for clarification too. But they sleep in a screened in, I don't know. Bree said, live. Oh, yeah, we're going to talk about her excuse too. Now, you guys, as you guys know, I'm not going to be talking about Bree and them. I will continue to do go over the court stuff and the documents, but that's all. But I do want to address what she said today because that's bullshit. Hi, Jamie. So I don't know if it's yesterday or today, whenever she said it. Bree said, was I trolling Grams? Yes, I was. I knew, or I don't even know what that guy did. I didn't even do my research. Well, that right there, that was your number one mistake. You're shouting. Matter of fact, and you haven't even changed your shit back. Your shit still says Daniel Fernandez. You haven't even changed your stuff back. And you guys are shouting, free him, without even knowing what he did. According to you. You said you didn't even know what he did. But then you said, but the reason I did it was, as if there's an acceptable reason for what you did and continue to do, right? It wasn't a one-time thing. It wasn't that you did it that one time and like, okay, take it back, whatever. That was the dig for dig, right? It wasn't that. You've continued to do it for days, okay? Get it, KK. My money's on you, honey. You have continued to do it for days. But she said the reason why she did it was because she wasn't even talking to Ruby at the time and she had a miscarriage. And now this is where the story doesn't make sense to me. She says, Grams called and said, did it pass yet? What do you mean, did it pass yet? You don't know you're having a miscarriage and did it pass yet? But then she says, yes, it did. I may go to the hospital, like, if it gets worse or whatever. And she says she sent a picture to Grams. Then she said that Grams, later on, after the whole Chrome thing, Grams sent that picture to T-Pages. Now, I don't know if that happened or not. But my question is, what the fuck does that have to do with Emily? You went after Emily. You brought up Emily. You brought up Emily's abuser. And it's not even an abuser. Again, I think people are saying it like it's a DV thing. That man rugged her and assaulted her. Right. It was a miscarriage. First there was a little bit of bleeding. The baby was fine. Then it was a miscarriage. And now it's like she's calling to see if it's passed yet. That makes me think the AB pill was taken if you're waiting for it to pass. Right. Look. Hang right there. That's how she knew it would pass. Right. That's how she knew that to watch within. So, anyways, she cannot keep her life straight. You guys, that's why you don't lie, right? Because if you don't, what the kale? Hi, love. Yeah, miscarriage. You're not waiting for it to pass. So get your lies straight. Or, I don't know, here's just a random great fucking idea, Brie. I don't know, say, tell the truth. And again, if Grams did that, is that crappy? Sure. That's crappy. I wouldn't do that to somebody. Does what she did warrant? No, absolutely not. And again, that's Emily. That's Emily's story. Emily had to come on here and share stories. And you went after Grams. Not okay. I had a miscarriage. I didn't take a pill though, and my baby. They told me wait for. Right, but I'm assuming then you had went to the doctor or something, right, Queen? First of all, I'm sorry that happened to you. But I'm assuming then you went to the doctor if they told you to wait for, probably, I think you're going to say wait for it to pass. But she hadn't gone to the doctor. She said that she was going to go after. And who knows? And maybe she did. I don't know. I just don't think that that's an excuse to go after her daughter. You know what I'm saying? She does not care what she did. Right. Or who she hurt. She doesn't have the capacity to feel. You were absolutely 100% correct. She has no ability at all. She has no empathy. She has no ability to feel any type of feelings. It's actually really sad. She's a very vital person. Yeah. Nothing she does makes sense. She will never take accountability. That's very true too. Yeah, she will not take accountability. She still doesn't understand the whole thing with custody and why Riley, she literally is the definition of a sociopath. Yeah, so. Anyways, okay, well, while we're on that topic, let's just knock out these court docs then. So we can be done and over with that. Let's see. They shouldn't be as long today. She is broken, and that's really, really sad. Thank you guys so much for all the daily heart means. I so appreciate you guys. We're back up to almost 500. Oh God. Oh, we're just getting started, love. I'm getting ready to read Bree's newest court docs that were just put in today. And then the other thing that I was talking about was how Bree said the other day that yes, she was trolling Grams when she made the profile, but she didn't even know what that person had done. She just did it. She just said it, like without even looking at it. No, I've only been on for about 50 minutes. And then she said, but she did it because Grams took a picture. Grams called her to check on her when she had her miscarriage and asked her, oh, did it pass? And she said, yeah, it just passed, and sent her a picture. And so she said, after the whole thing with Chrome, then Grams sent the picture of the miscarriage around to like T-Pages and stuff. So that's why that was her get back. Really just a mess. That was her get back. But again, my whole thing was, what did Emily do? Because that was against Emily. Yeah. No, there's no excuses for what she did. It's absolutely unacceptable. I will continue to read her court docs, and that's it. I won't be going over covering her and doing all that stuff. I pray that they are done in April and we done. Right, Lolita. Like, I can't really see Grams doing that. Okay, so there's only 23 pages. So did you guys send it out to everyone who wants to hear this? She did it because she was talking to the other T-Page. Yeah. Did she assume Grams sent a picture around? Right, she just assumed that that's... Because she's like, well, I don't know how else they would get it. Look inside the house, Brie. I wouldn't put it past Brie to send it around. Matter of fact, if I remember correctly, didn't Santos show it? I could be wrong. I very well could be wrong. But I low-key feel like I remember Santos showing it when it was still in the toilet. Civic Clock has it. She said, oh, okay. I don't know them. They do need the idiosyncratic treatment. Listen, I pray she don't come back over here full time. I am so glad to be done talking about her. Yeah, I don't know. And it could be something else. I vaguely remember a clip being sent to me when he was talking about how he was cooking and then she just kind of started bleeding, whatever. And I vaguely remember seeing like him flashing the thing to the toilet. And I remember saying, who the hell leaves it there and doesn't flush it? That's why I remember it. Like, who would leave it sitting there? You know what I'm saying? Unless that happened to somebody else. I don't know. To me, it's not that important. I don't care who has it, who did it. To me, it doesn't matter. It has absolutely nothing to do with Emily. I don't know. So, okay. Everyone's in here that wants to hear the court docs. All right, let's get going. Superior Court of California. This is respondent's responsive separate statement opposing petitioner's motion to compel. The first paragraph is just the respondent hereby submits that everything is true, blah, 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 blah. This is going over the damn demands again. We've done this 50 times, I swear to God. Okay, demand number 1, residence. Any and all documents evidencing your current, historic, and or any anticipated future residence, including but not limited to lease agreements, Airbnb rental contracts, subleases, subrental agreements, any retail property ownership documents and rental and or purchase applications for housing, lodging, residential address, apartments, and or home in which you have lived or intend to live from Baby W's birth through current. That was John's demand number 1. This is their response. Responding party objects to this request on the grounds that it seeks information that is irrelevant to the issues properly before the court in this parentage action and is not reasonably calculated to lead to the discovery of admissible evidence. The request seeks disclosure of responding parties' private personal information unrelated to the child or to the issues of parentage, custody, visitation, or support, and therefore violates respondent's party's constitutional rights to privacy under Article 1, Section 1 of the California Constitution. The request is overboard, unduly intrusive, and appears intended to harass or embarrass responding party rather than to obtain relevant evidence. Accordingly, no response will be provided. Responding party objects to this demand as it seeks information protected by the constitutional rights of the privacy of the third party who were not parties to this action. And responding party objects to this demand. This demand pursuant to CCP, blah, blah, blah. And this entire set of RPDs was served to harass respondent and retaliate against her due to her standing her ground on petitioner not micromanaging her time with W. On 9/16/25, after respondent sent petitioner the address of her rental on OFW, that's our fine wizard, for her upcoming visit with W in Texas per the court order, petitioner's counsel demanded numerous other pieces of personal information that respondent is not required to provide to petitioner, such as her flight information and itinerary with W. Just 1 hour after the attorneys stopped conferring about this topic via email, respondent's counsel was served with this discovery. These RPDs seek a laundry list of personal information on respondent petitioner has no right to. You guys, I feel like this is the same thing over and over. I don't know why I'm reading the same exact thing over and over and over again. And then this is, maybe what I'll do, okay, so on each one, there is an additional reason why. So what I'm going to do, I will read what the demand is. Every first response is, I'm not doing it because, well, I don't think I should have to. So all I'm going to do then is I'll read what the demand is, so you know, and then I will read the reasons for no further evidence required. Sound good? So that way we're not reading the same thing the whole time for everyone. Okay. Reasons why no further response is required. This demand violates CCP as it is intended to cause Brianna undue burden and expense in legal fees seeking information John already had. All pursuant to the court's order, John has been provided each Airbnb rental address via OFW at least 7 days in advance of Brianna's non-supervised visitations in Texas. Since the 8/27/25 orders to remove the monitor began with the September 2025 visit. Brianna books her Airbnb rental through her assistant to try to protect her privacy and disclosure of the Airbnb address to the masses. Brianna's assistant has an expectation of privacy from John as she is not a party in this case. Per the court orders, these Airbnb addresses are the only place W has resided during Bree's visitation time since September of 2025. Dating back to the inception of this case, John was provided Bree's address where she was living when she gave birth to W, as he flew in for the birth and visited the address multiple times. He also disclosed this address as Winter's residence on his UCCJEA form of 4/30/24. Conversely, in 10/24, when the parties stipulated to John taking primary custody of W in Texas in exchange for John dropping the first DVRO he filed in this case, John did not file and serve an updated UCCJEA form to reflect W's then current address. Per CRC Rule 5.52b, he had a duty to file and serve an updated UCCJEA form due to the change in residence of W. Fortunately, Brianna was never provided that address via the filings, nor even informally from her co-parent. She is so long-winded. When Bree moved from her first address to the MILF house. Again, I'll never understand this, putting it as the MILF house, but nonetheless, to the MILF house. John was also provided this address, called the police to this address numerous times, and showed up at this address with the police and streamed from outside of it. In short, there is a clear evidence in John via John's prior court filings and and content he posted online that he knew both addresses in LA where Brianna was exercising her custodial time with W. Despite W never living with Brianna at her next address in LA after she left the MILF house in 525, nor ever conducting her visitation with W there, Brianna provided her then expired lease to counsel for the address via email on 12/8/25. The lease expired less than a month after objections of these RPDs were due. During the meet and confer process on During the meet and confer process on this set of discovery, there was no new address to provide as Brianna had not secured a new lease yet, which was also thoroughly explained to counsel in Ms. Fonseca's response letter of 12/8/25 to Ms. Budnick's meet and confer letter of 11/21/25. Brianna did not sign a new lease until 12/31/25, long after the RFO was filed, and that address and lease were provided to counsel. I'm reading the newest court docs from Bree. I read some yesterday, and now there's new ones today. It is over. It's overkill. Okay, demand number 2. But the MILF house wasn't. I don't know. I mean, in reality, he did have these addresses. I don't know if there's like another reason they're requesting them. I have no idea why they're requesting more information. Right. Just look it up. Just put it in MILF house. Put it in your GPS. It'll take you right there. Oh, thank you, love. Yeah, my son's surgery is coming up end of February. I'm so nervous. Okay. Demand number 2. Lawsuits. Yes, that is up. The last nights when I read the stuff, that's up. Okay. Demand number 2, lawsuits. Any and all documents related, lawsuits. Any and all documents related to any lawsuits you are or have been involved in, whether as a plaintiff, defendant, petitioner, respondent, claimant, and or joint party, other than the instant parentage proceedings from April 26, 2024 through current date. Then there's the response, which just says it's none of your business. And then the further response says, this demand violates CCP 2023, as it is intended to cause Brianna undue burden and expense in legal fees, seeking information John already had. How would John have that information on whether she is involved in any legal stuff? I mean, I don't know what it matters. I guess it would for the DV stuff. But anyways. In Brianna's response to Family Law Forum Interrogatories Set 1, served concurrently on John's attorney with her objections to the RPDs, Brianna responded to number 3 legal actions as follows: not applicable. In other words, she responded under penalty and perjury that she is not a party to any legal or administrative proceedings other than the paternity case. Ms. Fonseca's 12/8/25 letter also explained to counsel she did a name search for her client on LASC's civil and criminal system to confirm that this response of form rogue number 3 was accurate, and it was. There were no she put there were not hits on, or for Brianna, I guess it could work, within the production period except for this case. But I think he's asking for, even if she's a witness too, I think she's asking for whatever happened on Catalina Island when he got arrested. Yeah, and she's also in, I read the civil cases too that she was in. Anyways, here she's going talking about her damn $1 again. Listen, this lady is pressed for her dollar. I'm surprised she didn't ask for $10,001, because here she goes about her damn $1. Ms. Fonseca also explained to Ms. Budnick how she could conduct the same search online for $1 through LASC's website if she wished to do so. Nonetheless, John is persisting with this demand over objection and with zero justifications for doing so in violation of CCP order. Demand number 3, airline travel. Any and all documents evidencing airline travel reservations, airline travel itineraries, airline travel schedules, airline travel payments related to airline travel by you and or the minor child from April or from his birth through and including the date of production. This demand shall also include documents relating to airline reservations made for you. I didn't even think about that. You guys probably hear that fan, huh? That was probably annoying as shit. Let me turn it off. Sorry. Just had the fan blowing right in your guys' ear. My bad. For you and the minor child as of the date of production, but for which said airline travel has not yet occurred. My thought process on that. Wait, this is key info for when she took. Oh, okay, AA. Now that makes sense because I was thinking, is this for? Let me read that comment of it. AA says this is key info for when she took W to the MILF house, the flights. Because I was thinking, is this going to be used for all the flights? They're going to show all the flights he paid and the amount of money that he put out and then the amount of money she put out. But that makes more sense. See, that's why she's here. And then again, they responded with, oh wait, hold on. Oh, responded with the same thing. We're just not going to do it because, well, we don't feel like we have to. And then the further response says, this demand violates CCP again and is intended to cause Brianna undue burden and expense in legal fees, seeking information John already had, and seeking Brianna's private information he has no legal right to. This RPD is also duplicative of RPD 6. Brianna's travel with W from Texas and California for W's birth to the completion of the DVRO trial on 8/27/2025 were already heavily litigated as part of the DVRO trial and are mute. John demanded Brianna's new travel itinerary or travel information commencing with the first unsupervised visitation in Texas with W in September 2025 via OFW on 9/14/2025. John and email on 9/16/2025, Miss Budnick. Brianna and Miss Fonseca responded that Brianna has an expectation of privacy in her travel arrangements, less the lodging address she is required to provide to John on OFW in advance of each visitation in Texas, which she has been providing in compliance with the court order. When asked what the legal basis of this request, Ms. Budnick stated the kidnapping prevention orders on the last page of the DV-130, yet there are no such orders there to be found, nor anything on that page related to their demand for this information whatsoever. When Ms. Fonseca pointed this out, Ms. Budnick again refused to explain her position, halted the meet and confer conversations, and said she would litigate instead. As outlined in the responsive declaration, Ms. Budnick helped define what travel was and was not at the end of the DVRO trial, i.e. movement from one place to another requiring a plane trip, and Brianna has not nor will be traveling within Texas or California with W absent a court order and or John's permission to do so. If she obtains either of those things and plans to travel, only then must she follow number 6 of the DV-145 to provide John with the flight information, itinerary, and a phone number where he can reach W. Counsel admitted via email on 9/17/25 that she was demanding this information from Brianna due to her own personal concerns about her professional obligation to her client related to Brianna's ability to follow orders. It is completely inappropriate to make a demand of a party informally, and certainly by way of formal discovery for information that is not subject to disclosures simply due to counsel's personal feelings. No, this is Bree's current orders or response. Okay, number 4, demand number 4, law enforcement records. Any and all, oh no, this would be the one about Santos. Okay, law and order records. Any and all documents included but not limited to reports, records, call logs, and the like related to any evidence or events involving you, whether you were a subject, a victim, or a witness in any law enforcement agency since his birth. This demand shall include but shall not be limited to all such documents related to any and all events involving you and any law enforcement agency, police department, police officers, sheriff's department, sheriff's deputy, residential and or corporate security companies, residential and or corporate security personnel, private security personnel, and the like, while you were staying on Catalina Island in June 2025. Again, the response was none of your business. And now the further response, first thing is the same line. It just is to cause her stress and fees. In Brianna's response to family law form interrogatories, set 1, served concurrently to or on John's attorney with her objections to the RPDs, Brianna's response, Brianna responded to number 3, legal actions as follows, not applicable. In other words, she responded under penalty and perjury, but she's lied under so much thing under penalty and perjury. Quit putting it in here that she does that because she lies every time. Anyways. Under penalty and perjury that she is not a party to any legal or administrative proceedings other than this paternity case. And then it says the exact same thing I just read above, so I'm not going to read it again. As explained to Ms. Budnick and Ms. Fonseca's, is this where she's going to go on about the damn dollar again? Okay. As explained to Ms. Budnick in Mrs. Fonseca's 12/8/25 letter, Brianna was not arrested and or cited for any crimes on Catalina Island in June of 2025, which Brianna's response to forms rogue number 3 confirmed under penalty and perjury, and Ms. Budnick could also confirm herself by paying $1, she's stressed about this damn dollar, to the LASC's criminal case name search. But they asked for witnesses or victims, if she was a witness or victim. As also explained in that letter, Mrs. Fonseca assumed the reference in Ms. Budnick's 11/21/25 letter to romantic partner of respondent and his criminal history was a comment about Santos Salazar, Brianna's boyfriend / father of unborn child. As mentioned to counsel on 12/8/25, Santos is not a party of this case, nor does Brianna have the ability to provide John any of Santos's personal documents. There were also no hit on Santos's name. You may need to pay more than $1 for 2025 in LASC's criminal name search, which Ms. Fonseca informed Ms. Budnick about. Just because the parties share a child together does not mean either of them are obliged to discuss their involvement with law enforcement on one another, as counsel alleged in her 11/21/25 letter. This is an enormous reach. Based on counsel's position, this would mean John needs to notify Brianna every time he calls the police on her when she is with W, which he has done repeatedly in the past, and it is assumed John would not be okay with this requirement. Then how do you know that he called the police? Wouldn't you have to know that? That's a reach. Okay, number 5. Counseling. Any and all documents related to your enrollment, payment, progress, participation, attendance, and or completion of any counseling, therapy, and or co-parenting and or parenting courses, classes, programs, or seminars, including but not limited to any such programs or courses at Cornerstone Counseling Center, and any and all documents evidencing your correspondence with or received therefrom. Skipping their first response. Second response is This demand violates CCP under, just causing her stress. As outlined in Ms. Fonseca's 12/8/25 letter, John was served on 7/3/25 with Brianna's completion certificate from the co-parenting / high conflict parenting class she voluntarily completed on 6/20/25, signed by Scott Barella, owner of the facility. Brianna's 7/23/25 supplemental declaration discussed the details of this case and referenced her lodging and service of the certificate. Ms. Fonseca shared the certificate with counsel a second time via email on 9/2/25, attempting to meet and confer with her, which ended up being to no avail, as to any objections as she had as this case counting towards the court's 8/27 orders that both parties complete a parenting class. Ms. Budnick's response to the email 15 minutes later and said she would look into it. Thus, this same document was shared with John twice before it was requested again by the way of these RPDs on 9/17/25. As in common with these court-ordered classes, this one included the only document Brianna received with her certificate. The class was completed privately over Zoom, blah, blah, blah. We now know it's the same class we had been talking about, which is the high conflict co-parenting class, which is not what she was ordered to take. She was ordered to take a parenting class, and she's still ordered to take 12 weeks of a parenting class. Hi, love. Hello, Michelle. Demand number 6. This is getting really monotonous and really boring to read. I feel like I'm just reading these same documents over and over and over and over and over. How you supposed to know this? Right. Okay, let me get through it. Number 6. Travel to Texas. Any and all documents related to your lodging, travel arrangements, travel itineraries, etc. for the child. First one, I'm skipping past. Second, Brianna's travel with W to and from Texas and California from W's birth to completion of the DVRO trial on 8/27/25 were already heavily litigated as part of the DVRO and are now mute. John demanded Bree's new travel information commencing with her first unsupervised visitation in Texas with W in September of 2025 via OFW on 9/14/25. John an email on 9/16/25 with Miss Budnick. Brianna and Miss Fonseca responded that Brianna has an expectation of privacy in her travel arrangements, less the lodging address she is required to provide to John on OFW in advance of each visitation in Texas, which she has been providing in compliance with the court order. When asked what the legal basis of this request, Ms. Budnick's statement was kidnapping prevention orders on the last page of DV 130. Yet there are no such orders there to be found, nor anything on the page related to their demands. Remember, that's what we went over yesterday. It's not the 130, it's the DV 145. When Ms. Fonseca pointed this out, Ms. Budnick again refused to explain her position, halted the meet and confer conversation, and said she would litigate instead. As outlined in the responsive declaration, Ms. Budnick helped define what travel was. Went over that. Counsel admitted via email on 9/17/25 that she was demanding this information due to her personal concerns. I already read that, so I'm not going to read that again. Demand number 7, any and all documents, included but not limited to correspondence reflecting and or evidencing the identity of any and all persons who have accompanied you or who are anticipated to accompany you to the state of Texas and or who have stayed with you and or who are anticipated to stay with you at your lodging at any point during your visitation and or parenting time with the minor child in Texas from April to current. The reason for no further evidence. First one is the same one. As to the supervised visitation, Brianna exercised in Texas from April to August. John already knew at the time of these RPDs were served who had been who had been present at those visits. As the facility he forced Brianna to use required his consent of any visitation. My voice is going out. Hey, Sal. After the court made it clear in May of 2025 at an RFO hearing that a facility was not required and the parties started using professional monitor service, the company had the same rule. No one could be with Brianna at visits unless John consented. Based on his consent provided for the May 25 visits, Brianna had her mom at the visit. Even though they just said in the papers I read yesterday under penalty of perjury, the mom hasn't seen her since Thanksgiving of 2024. Anyways, the only parties to this case are John and Brianna. Brianna is not obligated to, nor has the ability to, provide documents to John that belong to third parties, such as airline bookings by those third parties. Brianna and her attorney have made it a secret that Brianna and her attorney have never made it a secret. Santos has traveled to Texas with Brianna when she goes there for her unsupervised visits since September of 2025. He wanted to help his pregnant girlfriend with all of her luggage and getting each rental set up for W before W's arrival. Santos is from Texas and has business, family, and friends there and does not stay with Brianna. Is this under penalty of perjury? That's a lie. That is a lie. Let me read that line. Sorry, let me go back and read. Okay, Santos is from Texas and has business, family, and friends here and does not stay with Brianna when W is with her. Ms. Fonseca has repeatedly reminded Ms. Budnick there is no court order preventing Santos from doing this, yet she and her client seem to believe otherwise. At the 1/6/26 hearing, the court agreed that there had never been an order preventing any of this. These conversations between counsel dated back to 10/15/2025 when Ms. Budnick attempted to give Ms. Fonseca ex parte notice in flagrant violation of the latter's notice of unavailability pleadings filed and served on 10/7/25, right in the middle of Ms. Fonseca's out of office period. The main basis of the threat and ex parte RFO was the above belief that Brianna is not allowed to travel to Texas with Santos or for Santos to even be in Texas at the same time of Brianna during the visitations with W. None of this is even remotely true. Now, I don't know if that's exactly what they're saying. I don't think it's the fact that he can't travel to Texas because he can't keep anybody out of the state. Texas is a big-ass state. I think the whole issue is the fact that Santos is, in fact, staying with Brianna and her. That's the fact. That's so dumb. Number 8. Person sharing household and any all documents evidencing this evidence of the person in your household. Reasons why no further response is required. First one is just about seeking the legal fees. This is also an example of an RPD that is not code compliant and it is really seeking a written or oral response from Brianna in response to questions, not actual documents, which would be appropriate for special interrogatories of a deposition, but not an RPD. Long before serving these RPDs on 9/17/25, John knew of Winter's first residence in California with W, as he visited the apartment numerous times and saw with his own eyes that only Brianna lived there. Wait, after she lived there, the apartment, hold on. She went, not that it matters, because it truly doesn't matter, I don't think. But listen, I'm not part of the case. I don't know. But she had that apartment. Then she moved out of that apartment. She moved into the other apartment. Remember, because Valet was staying with her. Then she moved into the MILF house. But nonetheless, it don't matter. Okay. At her, and then it says, then her next residence is the MILF house. John knew from Brianna's constant streaming from the home and the many videos from the streams that he produced for the DVR trial that numerous other creators lived there, as did her two managers. At the next residence, Brianna was the only occupant. That's false. And only person on the lease. That's not true. Santos lived there. He was not on lease, but he lived there, and they say it in every video. They talk about that was his home too. He lived there too. He paid the rent. She couldn't afford the rent. He paid the rent. So it says Brian was the only occupant and the only person on the lease, and John had the lease and that address. This address was never filed on a UCCJEA form since W never lived with Brianna there, nor even visited there, as all of her visits were court-ordered only in Texas. During the 6-month lease of her apartment, as noted to counsel in the 12-8 letter, if Brianna receives an order to have her visitation in California, she will file and serve an updated UCCJEA form at that time. But for now, John has the lease, address, and occupants of Brianna's current rental. And again, that rental did not exist until long after the RFO was filed. Yeah, I think that's part of it too. Katrina said, he is almost 2 and she's lived in 8 places since pregnant. I think that's part of, right, what they're trying to get at too, is that there's no consistency. Someone sent me a clip today of Brianna getting a text message or something from her attorney saying, are you guys really moving out of that apartment? And she's like, no, oh my God, my attorney watches everything. Oh my God, that's crazy. She's like, no. She's like, I guess she didn't read the part get the part that there was a heat issue, but that's resolved, so we're staying. So maybe her attorney also is concerned, like, listen, you need to have some stability. Even though she just said the other day that since the judge doesn't care if she has a house or not, that she was going to move. Okay. Which one did I just read? Okay, number 9. Relocation. So just anything about her relocation. Ms. Budnick's 11/21/25 letter alleged these documents really answered to questions disguised as an RPD, but should have been a special interrogatories or deposition question, were relevant to the move away issue. However, it is John seeking to make W a resident of Texas, not Brianna seeking to move away with W. Furthermore, Brianna has been very vocal online as part of this case about being a resident of California, living in LA since she was 18 years old, and being established here. Her work being here, giving birth to W here, planning to give birth to her second child here, etc. She has made it clear she never plans to move out of LA County. So it is unclear as to what John even thinks, So it's unclear as to what John even thinks exists as to this topic. First of all, she's not established there. She's lived there, yes. Being established there is having a job there that she actually goes into. She has a job she can do from anywhere. So a job's not going to hold her to LA. Not having an apartment. She's in an Airbnb now that she's renting a month. I don't know what's going on. And to be honest, guys, I really don't care. She has no family there. She has no car. They're not established and set up there. You know what I'm saying? So I could see why that would be an issue. Now, this one I've never understood at all. I don't know how anyone would ever be able to provide this, and maybe AA can give us a little bit of insight as to why this would be requested, because I don't understand. I've tried to think of a reason why this would be requested, and I can't. Number 10, correspondence. Any and all documents evidencing correspondence between you and any third parties related to the minor child and or the petitioner. That would be everything she ever does. Like, all she ever does is talk about John. Not too much baby W. And that's from his birth. This is a good... Wait, what is it for? How could you do it, though? Like, I can't imagine. Oh, yeah, plans for... But how do you even verify that she's provided it? I knew I'd get her up here. I know how to get her up here.
Yeah. Well, I can't answer that in the comments, so I was like, okay.
I always find a way. Well, there's a will, there's a way.
Oh, I guess so. No, that is a good request, though. I do stuff like that all the time, too. They're not, the reality of it is they're looking for certain information to see if she provides it. So it's possible that John may have some pieces of a conversation that was provided by somebody who she communicated with. And, they just want to see what the full communication is, and they want to get it from her, and they want to see what she's saying about, John, and what she's saying about his family, and what she's saying about W and all that. So yeah, it's a big request. And it's a good request. I do stuff like that all the time. What will probably happen at the motion to compel is the judge will ask for specifics. Like, okay, what are you looking for?
Right. And, yeah. Narrow down.
So I'm sure that her attorney objected to it being broad and overly burdensome. Mm-hmm. And it is. That's a proper objection for that too. It'll just get narrowed down. So, but they're Well,
and I grasp that there's a reason for it, but I'm like you said, that's so broad.
Yeah.
And how would you ever be able to prove whether she provided all of the information? Like, granted, my kids are adults, so obviously I can't ever think of every single person I talk to about them or whatever. But yeah, it may make sense. I just don't know how they would be able to verify everything was turned in.
They're not trying to verify everything. Mm-hmm. Even if they ask, like, they're just hoping to get some information that will help them weave the narrative through the trial. So,
yeah.
And it's interesting because I was getting so freaking irritated because Fonseca is sitting here like giving these explanations when they've requested those documents for the explanations and they're not providing the documents, like the lease stuff. It's like, okay, he's asking for the lease documents. And so you can't just like say, hey, trust me, bro, especially for somebody who has no credibility with the court already. Right. That's not going to fly. So,
when she keeps saying, yeah, she said it she put it in the form under penalty and perjury of law. Well, when I read her last ones, we caught her in, I don't even know how many lies that we caught her in, and signs it under penalty and perjury of law. It's mind boggling to me.
Yeah, I can't even actually believe that she put that in her response. But
I love that John knows, or she says it on the internet, Your Honor. Like, she says all the time on the internet. If you would just log, Your Honor, listen, Linda, you just need to log into the internet, and if you would just watch her, then you would know too where she's at. Like, what? That just makes no sense.
But at the very same time, they are claiming that her online presence is a character.
Yeah.
Yeah. So it's like, what is it? Is it real or is it fake?
Right. Yeah. Very interesting. Listen, I can't wait for it to be over or move to Texas.
Yeah. Well, no, maybe they don't. I was going to say, I think Texas may stream some of these cases, but
Texas actually does stream some of them. I watch every single day. I watch a case in a certain court in Texas doing their custody stuff.
Yeah.
But all the documents and stuff are held private.
This is not related to these documents, but Bree's obsession with LA is so so I born and raised Southern California. So it's just like such a that's not the way people talk, that are from here. And it's not that, anyway, it's just so like, Anyway, it's just so strange her obsession with this like he was born here. We live in LA. I live in LA. I live in LA. I'm never leaving LA. And it's like, girl, like
It's such a thing that people who are not from LA that say that. Typical people who live in LA are not like, no, but I'm here. Like I'm established here. You're not established. You're established when you have shit. You
well,
may be
yeah,
a
and that's
resident, but there's a difference between a residency and being established. But
yeah, so actually, and she's actually she's right at some things. I know people don't like when I say that, but she is right that it is important that he was born here because that establishes the initial jurisdiction piece.
mhm.
But but there's a lot of other factors that go into play as to which court has jurisdiction, and I don't see any way for California to keep it once it's completed because I believe all of her parenting time will be in another state, all of her, everything. So there's multiple different factors like significant ties and case law on all over the West Coast. So Washington case law, Oregon case law, and California case law have repeatedly held that just one parent residing in that state is not enough of a significant connection to establish jurisdiction. That's not to say that the child in any case doesn't have a connection or a significant connection with that parent, which in this case that doesn't even exist. But it's not enough to establish a significant connection. So yeah.
It's funny because I actually just was listening to a case literally just I think on Tuesday. And it was a California Washington case. Dad lives in California. Mom is now staying in Washington. Child was born in California. This child is 16 years old. And so the stuff was kind of done in California, but there's an open case because of whatever. Mom just like basically abandoned the daughter at a mental health facility out here. And the mom's sister picked him up. So the aunt took it to a Washington court to try to get custody to get the sign for the medical stuff. And then he ordered a GAL, and so then GAL came in and she was like, no, there's an open case in California. We don't have jurisdiction. So they did like a court case with that. And California said, no, you guys don't have jurisdiction to dictate anything. You can do up to like a 30-day request, but it needs to be finished here. Then we'll ship it to you. But we have to close out everything here. So the way they got around it, the mom just randomly just disappeared. They couldn't find it. The dad ended up saying, okay, I'll drop everything here so the child could get the help that she needed up here. So I was thinking about this case, though, while I was listening to that. I thought it was very interesting.
Yeah, there's another way that a state can keep jurisdiction or release jurisdiction, and that's if somebody comes to the court with unclean hands. So if somebody's behavior is so bad, like a parent who just takes off, maybe that other state does have like technical jurisdiction. But if that parent who just took off and didn't give notice and it wasn't, appropriate, that state can kick it back to the other state also in some cases. So, but in this case, I don't see that as an issue. But LA is proper for right now. But once this closes out in April or whenever it ends up closing, being a final order, it'll move once there needs to be a modification or an enforcement. But it'll stay here, though, until that happens.
Right.
You can't. It's possible, though. I heard in the comments that 2K got an attorney or something in Texas.
Mhm.
It's possible that he can request at the close of this case for jurisdiction to be released. They can do that at the closure, so maybe they will do that. But it has to close here first.
Yeah, he did get my understanding. Now I don't know because I haven't seen no records, and I typically don't talk about it till I know. But I have heard that he has got an attorney. But I was out. Listen, I was only off for one day. I was sick for 24 hours. I slept like 20 hours. I was out of it. And during that time, a form was filed, and people were reading the form, and they went with it, and it spread that he filed to have the case transferred. That form was not to have the case transferred. It was, I think it's like updating his address.
Oh,
is what it was. But people, as soon as one person says it, it spreads like wildfire. So then I came back on and made a video. I'm like, you guys, I read it. This is not a transfer of to transfer the case to Texas. It's just updating. I believe it's updating the UCCJ form. Is what it was. I believe. I don't know. I can't remember now. I read it a few days ago. But yeah, that's what most people are talking about.
and yeah. And it will be moved though eventually. I mean, there's no way it can stay in LA.
Right.
It just doesn't make sense.
Yeah, they just have to finish this out and then move it.
Because the other thing about it's even tough for 2K at this point also because so the purpose of the UCCJEA is because you have to be able to have witnesses who are familiar with the child to testify. And if you're in another state, it becomes really difficult. And doctors and school professionals, like, they're not going to listen to a subpoena from another state. You have to register it. And anyway, it's a whole mess to subpoena somebody out of state. Many attorneys just do it, and then sometimes the people comply with the subpoenas, but usually school districts and medical professionals will fight subpoenas. So it can take, quite a bit of effort to get them subpoenaed, and it's just logistically a mess, So anyways, it makes sense for it to be in Texas because everything for him is in Texas. So
yeah, I just can't wait for it to be moved. I'm over it.
Yeah.
And it's literally just what's best. I mean, we've said it so many times, like, she would be the better parent to just say, you know what, I'm going to walk away until I'm ready. She literally says all the time, thank you, Chaotic, 400 minutes. She literally says all the time, she's like, I'm not parenting in Texas anymore. So now she's done this whole thing where I have a high-risk pregnancy, right? She tried to, like, bluff the judge, and the judge called her on it. Even though the day before she said, I'm on visitation in California. He needs to fly him here, and I'll return him. Well, first of all, that was the dumbest mistake, even if the judge is going to go for it, because your ass doesn't return him. So why would you be the return flight? You should have to pick him up, and he would return him. But anyways, so she could fly the day before. The next day she goes to court. She's not getting visitation in California. So then she says, okay, well, Your Honor, I'm high risk. I can't fly. Thinking, like, bluffing the judge, for the judge, thinking the judge would be like, oh, okay, well, then, yeah, you can have him in California. The judge said, okay, well, then you get 10 minutes a week of FaceTime calls. Then 2 days later, she comes out, oh my gosh, you guys, I just am constipated. I'm just full of shit. So I'm not high risk anymore, but I'm not doing any more parenting time in Texas. I'm not going back to Texas. I'm not. He can come here, or I don't know what, because I'm not traveling with a newborn. So I'll have my parenting time in California, and that's it.
Yeah, and that's a wild position to take. And I can actually see her taking that position in court, which is probably perhaps more alarming to me than her saying it on the internet. But the fact that I can actually see her taking that position in court is just going to go badly for her. So, it's sad. I think we are watching just a parent that will ultimately fade away. It's possible the only reason she won't do that is because the internet is, like, watching. But yeah, I think
she will. I absolutely, now that she has another baby on the way, allegedly, supposedly, possibly, maybe, I don't know, either a baby or just a big shit. I don't know. Listen, we don't know. We will never know with her. I do think that she will fade away because she's not going to get what she wants in Texas, I don't believe. And so I think she is going to fade away, and then she'll have another baby and she'll go there. Did you also see that she posted, someone said, oh my gosh, you were born to be in Hawaii or something? And she responded back and posted on the internet. Mind you, she has an active anti-kidnapping order or whatever that says, yeah, I'm thinking I should just kidnap my kids and just move here. Why would you post that? Well, you're in the midst of you have an active DVR and an anti-kidnapping order. Like, why even joke about it? I don't get it, because I'm all there, right? She's not. She thinks it's, I don't know.
Yeah. Anyway, I don't know. It's interesting to hear the objections, though, that she is raising. So just so everybody knows, like, I know it's repetitive, but you have to do that on every single request. So it's annoying, and it is repetitive. It's repetitive for attorneys too. But one of the things about like the flights and all the flights, she's like, oh, she has a right to privacy. Well, no, you actually don't. And when you end up in court, you kind of lose that right to privacy
Right?
because it helps for so many things too. It's not just, the flight is key for because she claimed she didn't know about the court date and she didn't know about what had happened. So when she bought those tickets, will determine, oh, did you intentionally mean to take off with your kid? Which I would venture to guess that she did. But also it shows about the money too. If she's trying to claim she has money or doesn't have money, it's like, okay, are you paying $2,000 for last minute flights? Are you, how much money have you spent on flights? And anyway, it just provides a lot of valuable information, but you don't have a right to privacy when you're in court.
Right. I thought the same thing. I'm like, that's crazy. No, we don't have. Yeah, no. But I don't know. Listen, Miss Fonseca and Brie, I think they're made for each other. Sometimes I wonder if Mrs. Fonseca, whatever, literally knows this and is just doing this stuff. Just like, I know she's not going to be there. I know she's going to fuck around and find out. Let me just do all this shit and just get the money that I can get out of her.
I promise you she hates this case. And they're not, like, I promise. And that's the other thing too about this is like when you have a client who's just refusing to provide documents, this is what you get. You get these weird objections.
Yeah.
And it's just she's doing what she can.
Sure, did you hear me talk about when she texted her yesterday?
No. Wait, what did I?
So they moved into this Airbnb, right, for a month or whatever. They said it was 6 months. Then they were talking 2 weeks in. She said the judge didn't even care that I had this house, so why am I paying $6,000 a month for the house? So we're moving back to Ruby's, whatever. So yesterday, I guess she was on live. Someone sent me see if I can find who sent it to me because someone sent it to me. Sends me a clip of she's on live and her attorney texted her and she says, "Are you really moving out of there already?" And Brie laughed. She's like, "Oh my God, my attorney just be watching everything." I can't believe she said that. She was like, "Oh my gosh, she must not have known there was a heat issue, but it's fixed, so I guess we'll stay here." But I'm like, I can only imagine the attorney, however she got the information they're moving, she was like, "This motherfucker, I swear to God." I can just imagine her like typing so hard on her keyboard, like, "I know your ass ain't moving again."
That's hilarious. Yeah, I mean, she has a really, tough case. I mean, I don't know how you
gotta feel bad for the woman at times, even though she drives me crazy with her cohort and the firth and all of her
and the dollar.
Yeah, she is obsessed with this dollar. It is in every damn paragraph. I read it so many times yesterday. Yesterday was like 110 pages. I stopped reading because it was just repetitive stuff.
Oh my gosh, I can't believe I always miss your lives. And I was here and I saw you reading the objections. I'm like, oh, this is going to rile me up. Like, what does she mean the leases are not relevant? That's like central to this case. Like, you think that a parent who doesn't have a place to live and who doesn't stay in one place for longer than 2 months is going to should have custody of their child when the other parent does have that.
Right.
I'm not saying that I expect that from, all parties. I know times are difficult and I think that there's a lot of grace there, especially for kids. But in this situation, like, absolutely not. Like, that's central to the case.
Yeah, it's imperative. And he thrives so much with John. He is doing so good, so happy, so healthy, thriving. And then you have that 1 week with her and they both just look miserable. They legitimately just look miserable the entire time.
Well, and I have to say, like, I will say, like, I've been pretty hard on him, but he has changed a lot. And if you'll notice too, they don't file crazy shit anymore. Like, they were for a while, they were just like, and I was like, oh God, like, come on, And it was stuff that wasn't going to be granted. Like, it's not going to be granted. And anyway, but he doesn't do that anymore. He doesn't
Yeah,
talk about like I really he has grown so much since this has started. So
really, really has.
and like I have been pretty hard on him because of that. And I see it's a very visible, a very real change. And I think it's just so good for both of them, for everybody.
Absolutely. Yeah. Yeah, he's
So,
doing great, and he's doing so much, like, growing outside of social media. He's investing in real estate now. He's learning from, like, he's just doing a great job. He's grown so much. Even before he grew, he was definitely the better parent, but he's definitely just grown and just matured. He's really, really grown. Now, someone did ask me to ask you this.
I see lots of questions that I have like earmarked to answer, but what?
Yeah. So no, I think that she's just talking because that's what Bree likes to do. Listen, you guys, Bree and Santos are not making money on social media anymore. That's what I tell you guys. You guys have to either don't listen after my whole cancel thing with them, or take what they say with a grain of salt. But Bree came on the internet and she was like, you guys, you guys have to be like me, right? And just always advocate for your child. And that's what I did. I never gave up. I found out that, or I thought something was wrong with my child, and the dad kept saying, no, no, no. But I finally was told by a medical professional that there is, and that is what's better, or whatever. But I'm like, if you have no, you haven't even had the child. How would you have taken the child to a doctor? Nor do you have legal custody to do so. Now, you guys, let's be honest though. We're all parents in here. When you guys have taken your child, when have they ever asked you to provide legal documentation that you have custody of your child? They don't. So in reality, she can really take the child to a doctor, right? Is she supposed to? No, but she could. Yeah, the advocate for it. I'm going to advocate for it. You haven't advocated for nothing. But so they wanted to know your thoughts on that. I think that's what you guys wanted to know.
Well, do they have, well, okay.
It's just something she said. She's provided no evidence. She's not said what the medical thing is. Why my whole thing though, if God forbid there is something medically wrong with your child, why the hell would you bring it to the internet? And this was after she had this whole thing about him potentially being autistic. Again, who cares? Why would you even bring that to the internet? Like, it's nobody else's business. That should stay off the internet completely. Just pisses me off.
So I think there could be a couple of things that are happening here. So she can access his records. She does. So legal custody just means that she can't make the decisions. Like she can't, and it's even defined in some states as like you can't even cut their hair. You can't, decide what religion they're going to be. You can't decide what medical procedures they'll get, what doctor they're going to go to, what school they're going to go to, what sports, etc. But she still has her parental rights, which there are certain rights that you have just by virtue of being a parent, unless expressly stated otherwise. She can get the documents herself. But what actually may be happening is it's possible that John, well, I don't even want to say, it's possible that John told her something that made her think she was right, because he's not going to share that. And she's not going to say that, oh, he's giving me this information, because that would indicate that he's being a good co-parent, which we've seen that he's given her information before about, certain medical things and certain stuff going on. So I think it could be one of those two things. I would guess it's more likely that John probably let her know, hey, if it is anything to do with like early intervention, like, hey, he's being evaluated. I didn't want to say that, but it's like, it could be something just as simple as that. And she's like, oh, see, I told you, so it would be like John doing the right thing, letting her know, and then her just running to the internet, which is stupid. And of course, John has grown a significant amount. I will admit, I'm the first to admit. So he's not going to come on here and be like, yeah, blah, 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 whatever I told her. Yeah. He's not going to respond to it. But anyway.
Yeah, he's keeping quiet. He's moving in silence. He's doing a great job.
Yeah. And he's doing what he's supposed to do if he did notify her. And if she got it herself, and it's okay if he didn't notify her either. I'm not saying that he
Yeah.
should. I'm just saying if he did, and if that's how she got the information, that shows good faith on his part, for court, if anything, right?
Yeah.
So, and I certainly don't think he has to because of, well, the DVRO doesn't include winter, right? They took winter. Oh gosh, sorry, they
That's
took
okay.
W
That's
off,
okay.
right?
Yeah, it's not about him. They can communicate and
Yeah.
have civil conversations regarding the child. No name, I agree with you 100%. She said, I really think it has no relevance to W. She just makes stuff up. That's what
Yeah,
I agree wholeheartedly with that. Yep.
that's also the other one. Okay, there's three possibilities, and that's probably more likely. And then they were asking, if you don't mind me answering this question, then I'll let you continue. But people are asking how the motion to compel hearing will go. It's typically a very procedural hearing, but in this case, I think it'll probably be interesting. The judge will basically go through 2K's requests line by line, essentially. So request one, and then, they'll read the request, or maybe they won't read it. Maybe they'll just ask for the response for request one. And then Fonseca will say, it's not relevant, blah, 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 blah. And then, 2K's attorney will say, well, it's central to this case, and here's why, yada, yada, yada. And then the judge will say, okay, you have to provide it. That's like a very shortened, condensed version, but they'll go through each request. And then some of them, the judge may put some guardrails up, like with the one you just read about the communication, all communication. They might say, okay, you need to tell what communication from who. And it's possible that he'll list a whole bunch of people and, then she'll have to provide it. It's possible too that there will be some crazy lies that are told. I would anticipate things like, I got a new phone, so I don't have those messages.
She's already said that.
Oh yeah. I would anticipate, like, oh, I automatically delete all my emails, or, oh, I didn't pay for the flight, so I don't have the information. I would anticipate a lot of that.
Yeah.
So yeah, and yeah.
You guys, I think, because I know a lot of people are like, well, then what? I think that information is relevant? Yes, but I kind of like what AA has said from the beginning. You guys, there's so much other stuff. I think it's going to end with John remaining, having custody. Visitation's going to remain in Texas. She's going to wither away, and I just don't think it's going to be an issue. But I don't know. I could be, listen, this is not my wheelhouse. Again, I do criminal shit. I don't know. I listen to family law stuff because I did family social work for 20 years. I didn't work in the court system with it, but I did help them with their court papers and whatnot. But I do more criminal stuff, so I know more about that. So that's why we love having AA as a fellow sock ganger. Then come up and let us know what will happen if she does not provide any documentation, even when the judge orders. I think then she can be hit with this sanction, because a lot of people are asking about the $10,000. The judge will let me say what I say first, and then AA will come up and she will slap me around and say I'm wrong.
I don't say I don't do that.
I know. I just like messing with you. I believe that they're going to deny the $10,000 request because the information is not frivolous, and the reason why the attorney is asking it, because she is trying to say that that John, not the judge, that John is only asking for it to run up legal fees and cause her harm. So I think the judge will deny it.
So it's funny that she's saying that, because the way to respond to discovery is to provide as much as possible. And what I will do in some cases, it depends on the case, because sometimes I'm responding like Fonseca. So I don't want y'all to think I'm below this, because but the reality of it is when I do stuff like this, I'm wanting that court case. I'm wanting that hearing. I'm wanting that, not for myself, but all of our clients have different goals. And I would say, I would say that it's pretty clear that Bree's goal is to make John expend enormous resources, regardless of the outcome.
Yeah, she said that.
Yeah, there you go. So, so that's why you're getting the response that you're getting from Fonzie.
Sorry. Hold on, you guys. I don't want any. Sorry, I want you to finish up. I do not want any talk about baby W's diagnosis or non-diagnosis, and if you guys are having conversations in regards to autism, just in regards to your child, that's fine. But I only like information that is documented, courts, medical, whatever, through here. So I don't want people going in saying, oh, I saw people talking in Angie's thing about him possibly having because of somebody. Like, people will twist everything.
Oh yeah, no, that's not what I don't even.
No, not you. I just saw comments slip by. I didn't even read them all. I do not want that. Baby W is just fine. He is on track. And listen, and even if a child does have autism, they are perfect how they are. That is how God created them. It is okay. So please, that's not what we do over here. I don't want any conversations about that over here. So I would like that to stop. Thank you.
I did not mean to spark that though.
No, you didn't at all. No, I brought it up. Because of what she had said. So I just don't want people to be having those conversations there. Mods, if that continues, you can mute. Don't block, but just mute that. I don't think anybody means any harm by it at all. I don't think that at all. I just know people twist things. So okay.
Yeah, but that's a very good point. So thank you for stopping that too, because I also don't want to be associated with that. I didn't even want to say what the potential could have been, but anyway, okay. Yeah. But yeah, so if you want to truly avoid a hearing like this or a motion to compel hearing, then she should have provided as many documents as possible. And what I would tell a client of mine who is in a situation like this is I would say, just give me everything and we can redact the hell out of the stuff, like I am not opposed to redacting like almost everything on a document, but still providing it. So that way you're not really forced to a motion to compel. You still may end up with a hearing on a motion to compel, but,
right.
She would have provided at least some documents, because it sounds to me like she didn't provide any, like not a single one from any request. And this is their first discovery request.
Right.
They haven't even done discovery, really. So
thank you, Sopo. The answer is yes, I will. Yeah.
But yeah, he will not be sanctioned, but she may.
Yeah. That's someone just mentioned that. Thank you so much. Who said that? The only document that they Mama 1085. Thank you, love. The only document she provided in all 12 demands was an expired lease. That was the only document, was an expired lease.
Yeah. And and I'll just say to okay, don't hate on me for this, okay? To Bree's defense, this is probably actually really embarrassing for her. And you have to think about this. This is a person who puts on this facade, pretends like they're always happy. Oh my gosh, what is that? Oh my gosh.
It's just me swimming across the screen.
Wow.
No.
No, but I saw it too. The
so
whale.
Beautiful. I love it. Thank you so much. That's my favorite. I love, me in the Pacific Northwest, we love them. They just be flipping by, especially when they have the babies.
Yes. Yeah.
We're going to be doing that on our vacation. I'll be taking you guys with me. We're going whale watching. That's your last clue. 2 weeks. We're on vacation, Suck Gang.
I want to go up to Gig Island and go do the whale watching there.
Yes.
But anyway, I think that Bree is actually not providing this stuff because she's embarrassed, because it'll all end up on the internet, which she's done to herself. Like I'm not justifying it, but this is like, it's really embarrassing for her. It's embarrassing for her. And she puts on a front like she doesn't care, but she cares, she cares. This is,
Yeah,
You know.
I'm with you because it's a blow to her image. She has tried to put on this image that she is worth so much money. She has all this money. She is the best. Blah 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 blah.
I
And now
mean,
it's coming
she's
out.
quite literally like a total loser. I mean, you guys, and I'm not trying to say that to even be mean. You guys, I mean, you guys all call me Brie lovers and 2K hater. I mean, she just is like, she doesn't have a place to live. She has nothing going for her, which is really sad. And so when you have to provide the proof of that, it's embarrassing, you know?
And you guys, AA has always said, and this was the very first time AA joined. I said, I want you to give us your unbiased opinion from both sides. And so I think people were really like kind of pinned you that because I feel like it's my fault because I asked you to give us your unbiased opinion if you were her attorney, his attorney. And she has done that throughout, and she has maintained and fully give us an unbiased opinion for the last year. And it has been such a blessing to have an active family law attorney. What the heck is that?
Oh,
no way! That's so cool. Thank you.
It's like Coachella up in here. Wait, sorry, I just had
hey,
this.
You guys can do whatever you want. It's Coachella. Let me get a sip of my Diet Coke. Anyways, that was beautiful. Thank you, love. Reminding me of my childhood. But and she was right in the beginning, and we talked about that. And it's like she said, it slowed down. There was just not Coachella, stop it. There was so many orders in the very beginning. It was very, very overwhelming, and he's grown, and that has slowed down, and they've kept it right to what is pertained to the case. And since that, AA has said, listen, stop it, delightful. Oh my gosh, love.
Oh, that is so cute.
He was hanging by his arm. That's Brie hanging on her lifeline to hope she's going to be able to still see John. You see how she's doing her makeup in order just to have her visits with 2K, or literally with Baby W. Someone asked her how her visit went. She was like, so good. 2K is there. She's like, John's there. I mean, he's like there playing with him, so I get to see him. She is getting her face. She is full beat going into her 10-minute visitation. Okay.
Yeah, it's embarrassing.
Oh, someone else asked this too. Yes. Listen, I don't know how I've been blessed to find the people that I have, but I'm so glad. Delightful. Thank you, love. It's about to be me when I get off eating, getting ready to cook.
Oh my gosh.
But what was I going to say? Oh, what do you think? And I think we talked about this, about her not doing her visits for 3 months.
Oh yeah, I mean that's going to be really bad for her.
That's going to be hard to come back.
And so I think somebody said, I forgot that was a question. Somebody had said that Brie had said that the judge didn't care. And I think the judge Brie mistook what the judge said, because the judge doesn't care if Brie isn't going to make an effort. But the judge isn't going to make W come here, or I'm sorry, come to California. I'm in California, so I say here. But anyway, the judge doesn't care about Brie not making it or making it. The judge cares about W. Right. And so that's why, the judge was like, okay, fine, no problem. We'll just do the Zoom. And so she's either just saying that because she's trying to make herself feel better, or she's trying to rage bait or whatever. But I think it was pretty obvious in the transcripts, because didn't you read that part of the transcript too?
Which one?
The part where, oh no, was that in the
where when she said she had a high risk?
Yeah.
It wasn't in the transcript, but it was in the minute order, or in some order that came out, because I don't have the transcript for 1/6 yet. I was going to order it, but then instantly her attorney said, I'm ordering it for whatever, for April. I'm ordering the transcript for January 6th. I'm like, well, then I'll save my few dollars.
Yeah.
But Brie said, as soon as they said that visitation will remain in Texas, then she said, well, oh, but Your Honor, I'm high risk. I can't travel. And the judge said, okay, well, then perfect. Then you'll have, you can have a FaceTime call. I'll give you 10 minutes a week.
Yeah. So,
and she was shocked. She really thought that she was going to be able, and because then she came on and she said that she's like, well, I get FaceTime visits. because I can't travel. She's like, and then in 3 months, well, in April, I'm sure she'll give me visits here, meaning California.
No.
She said, because then I'm going to be at the end of my pregnancy and then I can't travel. And then in 3 months again, then I have the baby. I can't travel with a newborn. So I'm not doing any more parenting time in Texas. So she's just going to have to give me visitation in California, or I'll just be doing FaceTime.
Yeah, no, it's not going to be in California.
Yeah. Question, if she travels before court, but not to see baby W, will the judge do anything?
I mean, the judge won't do anything, but she just
It
looks
just looks bad.
bad. And that is something, like, a lot of people are upset about all the lies and all the perjury and all that stuff. And her being held accountable looks like what you see right now, right? The judge she's not credible to the judge. That's why the judge didn't care that she said she was high risk. That's why the judge was like, okay, fine, no problem. Then you're just going to get Zoom called, very nonchalant,
Right.
is how I imagine that occurred. So that is the accountability that she has for lying, is the visits aren't going to be here because she's just not credible. You can't believe anything that she says. So, and, I do think that John, like I said, I give props to John. He's grown a lot. That's been very clear. He's done a great job. But he also has a credibility battle to climb out of. Those transcripts, the judge was not pleased with some of that, but he hasn't done any of that anymore. He has truly grown from that. So I think he'll be able to establish and show that, and that it won't impact him in that way. But they kind of both have some credibility challenges with the judge. But that being said, that is her accountability.
Yeah. I think, like you said, I think he's really outgrown that. And I just, listen, I've said from the beginning, I think it's going to, thank you, JJ. Thank you, JP. I got to say this. See, I saw the football helmets. I had to shout out my team real quick. But yeah, I've said from the beginning, I think that he's going to remain with full custody. Now it'll be interesting. I think that he'll, when the DVRO ends, if he doesn't file for another one or is granted another one, we don't know how that's going to go. I think, this is my personal opinion, I don't know. I think he will remain with full physical custody, and I think they'll go to 50-50 legal custody, and I think that visitation will still remain in Texas.
Yeah, I was pretty certain about the 50-50 legal custody also for a long time, and I'm sort of shifting. It depends on how 2K's attorney is able to position it, but what's concerning. Oh, that's so cute.
So cute. You're just making my whole day. Thank you, love.
But what's concerning is, and hurtful for her, is that she just made this comment, right, on the internet.
Yeah, so cute. About kidnapping all the babies and moving to Hawaii.
No, I don't want to bring it up again, but
about the about the child. Yeah.
So that kind of hurts her with any kind of legal custody. And then I do think there is a concern for her just taking off with W. And the judge is pretty clear that it's not kidnapping, which all y'all hated on me, by the way, for that. I kept on saying, I'm like, it's not kidnapping. And then the judge feels the same way I do. And she gets mad when they all talk about it. And it's funny because Bree's own attorney keeps calling it that.
Anyway. So it's only her attorney. It's not John's attorney saying it. It's only her attorney saying it.
I know. It is really kind of funny. Yeah. But I do think that there's some concern that she would do something like that. And when you have 50-50 legal custody, it's really hard to retrieve the child, as you guys all saw. What he did manage to get is like Herculean, efforts to do that. Like, that's not easy to in the status that case was, to have such quick, swift movement. So anyway, so I think if he is able to, position it in that way, she may not have any legal custody
True.
because it'll make
Think
it
about that.
10 times more difficult for him to get, because a police officer is going to say, oh, well, she has 50-50 legal custody of this child. So it's not custodial interference. It's
Yeah,
not,
that's true.
so I just think with how she's a flight risk because she doesn't have a place to live. She's not established anywhere despite her. She's a flight risk because of that. And she's done it before.
Very
So
true.
plus she's like airing out potential medical stuff on the internet. So,
Well, and she said too that she would even move to Mexico, take him and move to Mexico because that's where Santos's family is. And I think you guys, and I could be way wrong with this, but I do think, oh, you guys are almost at 90,000 taps. Thank you guys. The reason why it wasn't, well, we do know this. The reason why it wasn't kidnapping or adoption, right? Because she wasn't technically served properly. But if that hadn't come out yet at that point, right? So 2K was able to prove the document to show that she was not supposed to have the baby in California. He had the proof that she was supposed to turn the child over. But it wasn't until after all of that, when he got the child back, that they were able then to see that she was not served properly. It's when she got her attorney, right? But had they had that back then, he may not have been able to get him back so quickly. And that would have been a big kerfuffle.
well, and he still had to go to court. He still had to get an ex parte order. So even despite showing all of that, he still had to get the ex parte order. And I think he had to go back to the court twice, but I don't know. I'm not recalling perfectly, but I think he had to go twice because he went once and then they told her to meet him at the police, right?
Right. Yeah, she had to meet him at the police station. She's like, I'm
she
not
didn't.
driving 30 minutes away. I'm
Yeah.
not doing that. No. 419, see, that was the whole thing, right? She was served the document. She did read it online. She knew what it was, but there still is a process. And she was not, there was a change in attorney. So when she had her attorney, she had signed that she would take email, like to be served via email, right? But then when her attorney left, and correct me if I'm wrong here, when her attorney left and she was then pro se, she had to re-sign up to be served that way. And that was not done. So even though she was served via email, there was no notice on there that was an acceptable form of being served. And that is why this was not a kidnapping charge, because she was not served properly. Even though she read it online, she was served, and she even sought an attorney's advice on it, and they said, no, you better hand that baby over, and she chose not to do it. So that's why.
Yeah, and people are asking about that. She did skip the court date, and all she had to do was show up. Anyway, all she had to do was show up. In fact, that is, I guess it's sort of fortunate that happened. I guess you can look back at things and say, oh, well, that definitely happened for a reason, because truly all she had to do was show up and that would not have been granted. He did not have enough grounds to get that, but he got it because she didn't show up. And then it just snowballed. It just snowballed into just a total cluster. But
Yeah,
it turned out to be truly the best thing. So as chaotic as that was, and as traumatic and hard as that was, that is what has led to the most stable and best plan for W, and it wouldn't have happened otherwise. And I know it's so hard to think about those things, but it's true,
absolutely.
So
yeah, we're Gilda, we're actually just getting ready to go into that. Well, first of all, Bree's not high risk anymore. She was never high risk because she never even went to the doctor. She just made that up. She was trying to bluff the judge. She was literally trying to bluff the judge to get the judge to give her visitation in California. But she's not high risk anymore. She is full of shit. Literally, she just said she's just constipated, and she's already planning a trip to Vegas for Santos's birthday. So she's able to fly. She's just not able to fly to go see her child. So I don't think the judge won't have to ask for it. But the very next demand is
Didn't we call that? Didn't we call that? Didn't we say
we
like
did.
just a couple weeks ago, like, oh, let's see how long it takes for her to go somewhere?
Yep, absolutely. And she's already planning. But literally the next, can you stay on for just a minute while I read these last two demands?
Yeah, I'll
Answer the
mute and
question.
then you can ask any
Okay, so
questions.
demand number 11 is impediments to ability to travel. She's asking why she can travel. Any and all documents evidencing or relating to any present or future inability by you to travel to and from the state of Texas for your parenting time with the minor child. And the first one is it's not your business. Next one. So this is the most current one that just did today. This demand violates CCP and it is intended to cause Brianna undue burden and expense in legal fees seeking information John has no legal right to. Nay, thank you. Walk like an Egyptian. Thank you, love. At the 8/27/25 conclusion of the DVRO trial, Brianna's pregnancy was discussed on record. The court indicates it may move Brianna's visitation with W to California once she became too pregnant to easily travel to and from Texas. The pregnancy was the obvious impediment to ability to travel. John was seeking documents on, and John has no legal right to Brianna's medical records. Due to the concerns that the court and Miss Budnick would have questions about why Brianna was not hugely pregnant at the 1/6/26 hearing, Brianna had a printed copy of limited medical records she was willing to share in chambers off record to explain the situation in a private setting. Unfortunately, Ms. Budnick failed to give the required written notice to her and her client's intentions to appear remotely for the hearing. So when Brianna and her attorney arrived to the court expecting to exchange this information in person, opposing counsel and John were not there. For all other remote appearances, Ms. Budnick has advised Ms. Fonseca via email of her intentions to appear remotely. On 8/27/25, conclusion of the DVRO trial, the court clearly states that the 1/6 hearing was being set to review the FC 3044 presumptions against joint legal and physical custody and to discuss possibly moving Brianna's visitation to California. Brianna filed and served her pleadings package before the hearing on these topics, but John did not, also a first. This was the only hearing Ms. Budnick failed to give advance notice of her RE, her and John remote appearance, and the only hearing she did not file a pleadings for John's beforehand. It was clear from these factors that everything lacking here was strategy to push the FC 3044 hearing out by several more months, which unfortunately worked. Brianna was only comfortable bringing one set of these limited records to share in chambers, then would take the documents immediately home with her to ensure they did not get disseminated online, nor her private medical information become part of the public record, i.e. the transcripts. Brianna is under no legal obligation to provide her otherwise private medical records.
Yeah, yeah. You have to file for a protective order.
For her not to provide it, you mean?
No, for 2K should have requested a protective order. It's a protective order on documents so that they're sealed, they don't become so health information, like from your therapist or your psychologist, all that information should be protected under like a confidential health protective order.
Yeah.
Or confidential health information, but we just call it a protective order. So the appropriate or the proper way to have requested her medical documents would have been to file a qualified protective order with the request. So
Yeah.
It doesn't, I don't know if he did that or not. I haven't looked at the docket, so I don't know if they did that. But I mean, that's fair, right? You don't
Yeah.
want her
Well,
medical documents going all around. But
no, I agree. And I already told everybody too. I was like, listen, if by chance it comes out, I will not be discussing over here. Now, as soon as it did, she has gone online and said that she's talking about her pregnancy every day. Everybody knows her due date, everything. She's putting everything out. She just wanted it like it was just a thing. But I'm not going to tell the courts. But I'll tell you guys. I guess I don't know.
well, because I wonder if it. Well, anyway, whatever. I would just wonder how true it is. And you see, what medical records would show would be like, okay, well, when did you actually get pregnant?
Right.
If you are, I mean, I don't know. I hate that, but
No, we're right there with you.
it's
We don't
um,
know.
that's what happens when you lie about everything. So
Exactly. This is the very last demand. Number 12, travel within Texas. Any and all documents, writings, or correspondence between you and any member of your family reflecting, discussing, or otherwise referencing any family holiday plans you have and you wish to uh, what you have or in which you desire to participate for the 2025 calendar year. Skipping the first one. And then this is her reasons why no further respondents required. Again, the demand violates CCP and it is intended to cause Brianna undue burden and expense in legal fees, seeking information John has no legal right to. John has no right to Brianna's private communications with third parties. All third parties, not parties to this case, have an expectation of privacy as to John. Brianna also tried to discuss her 2025 calendar year plans with John on OFW back in 925 before the RPD were served, as discussed in the responsive declaration. She and Ms. Fonseca both tried through John and Ms. Budnick to obtain approval for Brianna to take W to Corpus Christi during the Thanksgiving week visit to stay with her mom, but John refused consent. So the family came to the Airbnb in Dallas instead. This topic was so heavily discussed at the 1/6 hearing and is now entirely mute as to any 2025 plans. Ms. Budnick 11/21/25 letter argued that W's relationship with the community and or family members is part of the Lamaguska analysis, yet this topic is not one of the Lamaguska factors. Even though John denied Brianna the chance to bring W to her family in Corpus Christi for Thanksgiving, the family came to her. Family time is still bonding time, regardless of where it occurs. And that is the end. Dated January 27, 2026. That is the end of that.
that last request will for sure get granted. And fine, to Fonseca's point, if the third party has a right to privacy, okay, we'll just redact what the other person said. But what 2K wants to know, or what I would want to know if I were to request this, which I would, I don't want to say what 2K's attorney wants to know because I don't know. But what I would want to know is, did I don't know, does she even have family? Like that's the thing, like she like faked this relationship with her mom. I hate to say that, but I feel like it's very much so not real. And so did they really go visit her? I mean,
yeah, her mom came for Thanksgiving. Now I don't know, much more about her family, but she has a sister, I think, that lives out here in Washington. And so yeah, some of the family members came up, but I don't understand. Like, so yesterday when I was reading, they put out the OFW messages, and he was like, when she asked about the request to go to Corpus Christi, he said no because that's not a surrounding county of Dallas, and she was like, God damn it. She literally said, she's like, John, Corpus Christi is a city in Texas, and I can take him in a city in Texas. Or it's a surrounding city. It's in Texas, so I can take him there. And he responds back, I shit you not. I almost spit on my Diet Coke. He says, Brianna, tell your what did he say? Brianna, tell your email, or tell your attorney my attorney has emailed her. Like it was so funny because the court order does say visitation has to happen in Dallas County and surrounding counties. And then her attorney, so Miss Fonseca responds back, I don't know where John came up with this list of the surrounding counties. How would anybody know this? Where did he just randomly pop up with this from?
A map.
A map. Literally, look at a map. Dallas County. Any county that's touching it, it's pretty simple, cut, dry, easy. So it was yesterday's reading was quite entertaining. It had me laughing.
What was yesterday?
So yesterday was all of this was done too, but hold on, I'll pull that one up. It was a freaking 110 pages. But let me pull that one up, I'll tell you. Because this one was, what was the name of this order? This one was respondent's response, a responsive separate statement opposing petitioner's motion to compel. And then yesterday was, let me pull it up. It was respondents' counsel's responsive declaration opposing petitioner's motion to compel and supporting respondents' request for FC 271 sanctions as attorney fees. So it's kind of the same. Yesterday's was a legit shit show.
I absolutely cannot believe that she's requesting attorney fees.
Yeah, it's $10,000. I'm surprised it's not 10,001. We talked about the San Antonio. It's up on my YT if you want to listen to it while you go to sleep tonight. It is quite comical. Yeah, you guys, we did talk about that the last time she was up about taking the baby to San Antonio. I can't remember exact because I said if I have 100% proof that in fact the child was there. I think she said that the judge would, I can't remember exactly what she said. But that the judge would talk about it. And again, I just think that the visits just aren't going to happen outside of Texas. I can't remember.
Yeah, I don't think she's going to get visits out of Texas.
Okay, I will pin this. Oh, I don't want to respond to my comment. I can't pin it. Well, I put it in there. In it, you guys, my YT is the same as my TikTok, AngieW1470. And I have everything. All my videos are up there. The video from the night that we did, that I had Grams' daughter up, because of TikTok's glitches, when that downloaded, it's very glitchy. So that one does, people are watching it. It has hundreds of views. So people are watching it, but some people complain because it's kind of hard to watch. I'm not going to have anybody else come up and join, guys.
Well, I can jump down too. I know you're.
Oh no, you're fine.
Thing, but yeah, this got me riled up. Not gonna lie.
I'm curious to see what your thought of yesterday's was, because it was a lot of bullshit. It was just a lot. And like I said, now that I have it up, hold on, let me pull up, because I have to. I got to get your guys' response. If you guys didn't see it yesterday, I'm going to go to the spot where, into the exhibits where we can see the OFW, so you guys can hear it, because it was freaking comical. Let me see here. Okay, here, hold on, I'm almost there. Is it this one? Okay, let me start with this one. She's asking like what he likes, what he eats, what sizes he are. He's like, so she says, these are all my dates. And then she says, and put November dates in Corpus Christi. He said, those dates are fine, but no, Corpus Christi is not a surrounding county. She's like, it is a surrounding county in the state of Texas. Like, you idiot, John. It's literally like, good job.
Oh my gosh.
It is a surrounding county in the state of Texas. He says, that is not a surrounding county of Dallas County. Here are surrounding counties. Denton County to the northwest. Collin County to the northeast. Rockwell County to the east. Kaufman County to the southeast, Ellis County to the south, and Tarrant County to the west. And then she says, per our DVR, or page 11, blah, 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 blah. She's saying whatever. Where is the one, though? I got to find. Oh, but okay, let me go to the next one. I've got to say where he says that about the attorney was absolutely hilarious. Oh, here it is. Okay, let me read these ones. I'll send you, this is from Brianna John. I'll send you the dates that I booked. I booked it, but my assistant booked it, so it's not going to send you her information. Or that's not the information I owe you either. I only need to send you the address where I'm staying. I will send a screenshot of the dates that I booked the address. And then this one is from Brianna. It's backwards. So, John, let me remind you that I only need, well, first of all, let me tell you guys, for you guys who don't know. So she sent him the information for the, she sent him the address, but she sent a screenshot, and she was checking in the day before, and it was only for a 1-day reservation. So yeah, he was kind of concerned. He's like, nope, I need the whole reservation, the address of every day that you're going to have him. This is a date that you don't even have him. So then she says, John, let me remind you that I only need to send you the address where we are staying. Here are several screenshots of my booking confirmation with dates and address, since it's something you mentioned and seemed uncomfortable with. I will say that the date of check-in is a day before I get W. That's for me to check in and get everything set up for him. He responds back, Brianna, let me remind you, my lawyer emailed yours.
Oh my gosh.
I just thought it was so funny. Then she says, yes, she responded to that. Yes, my lawyer forwarded me their conversation, and it's just a repeat of ours, basically, and that you're not understanding the court order and attempting to micromanage my visits again. I sent you the address with dates, even though the court order states you only need the addresses. Several times with several different versions, yada, yada, yada. So it was quite hilarious. And that one was 110 pages as well. So it's just been nonsense.
Wow. Well, hopefully it'll be over in April.
Yeah, I hope and pray. Just so they can even move on. Like, she should want this over and done with so she can focus on her new pregnancy.
Oh, she does not want this done.
No. I agree. She should. One would think you would want it over.
This is her connection still.
No, you guys, the Grams thing isn't going to affect anything or be used, in my opinion, because again, it doesn't have anything to do with it. You know, yeah, it shows horrible character and it shows how she is, but it's not going to, has nothing to do with the child. He wasn't there through any of it. So, in my opinion.
Guys, I don't know what she's gonna do. Anyway, I guess we'll see.
Yeah, crazy. So that was the end of court docs for today. Who knows what's going to happen next? They do have their motion to compel date on, I think it's April 9th. So, or not April, what am I talking about? February.
I was going to say, did they push that out?
No, February 9th, sorry. And then there's one in April. I'm not sure what the April date is for.
April is for the actual trial, I think.
Yeah, I think so, something like that. So, will they move it to Texas? Yeah, once it's closed out here, most likely. The trial is April. So that's what we want, is we want to get to April and have it be done. So.
Yeah. Oh, what a mess. I'm glad this is not my case.
Right, I can't even imagine. I can say Miss Fonseca is not paid enough. Even though she drives me nuts.
I don't know about that.
Yeah, to work with Bree. My YT is the same as TikTok, AngieW1470. And I'll probably end up here in about 15 minutes, so I'll have time to get it put up tonight.
Oh, yeah, I have opinions on that other Stand With Meg lady.
Yeah.
I'll keep it to myself, but I have.
Well, she's they asked Donkey asked, would you represent Bree? She said she would be a nightmare.
I would not. But part of the reason why I wouldn't is because when I take cases that are like bad like this in a really bad place, because I do, that's actually, I take most of the cases that I have are in a really bad disposition. Um, Generally speaking, it's typically the fathers who are in these bad, spots. But I make them do certain things. Like posting on social media would be a hard pass for me. Also, I would require therapy and things like that. Not require in a way that I don't mean to say it like that. Let me rephrase. I want if I take a case that's in a really bad disposition like this one is, I want to be able to go to court saying that my client did all the things to change themselves. And so when I take a case like this, I will say, okay, I will take your case, but here, this is what you have to do. And if you're not willing to do that, then I'm not going to take it to trial because I'm not going to make myself look like a freaking fool, And Bree could have done a lot of things to make herself get visits in California and to be better positioned for the hearing in April. And she's done none of that. And I think that is kind of bad lawyering. I mean, I don't know. I don't know what she's advising her or telling her or how much, but I think a good attorney really helps their client through the time that they're in. And I think that that's lacking. And
I agree.
she needs a really strategic attorney, and it's clear to me that Fonseca is just not a strategic attorney. Like she's just going in and she's fighting, like she is, she is. Like we can see by the transcripts that she's fighting, but it's futile. It's ridiculous.
Yeah. Well, it's hard to fight when your client isn't fighting. Her client isn't doing what she's supposed to do. And I agree with you on the therapies and stuff. I do the same thing on the criminal side. Like I tell them, we'll just say that their case was the DV case. I tell them before the judge even orders you to do, because I can guarantee they're going to order you to do it, go in there already and have it already completed. So when the judge say, you know what, I already have it done. I've completed anger management. I've done some UAs. I've completed the DV class, whatever it is, right? Have it already completed, because then it shows the judge that you understand and you're going to push through, and it usually works.
Yeah. Just get ahead of it. Get ahead. And the other thing too, and this is good information for anybody who's in court right now, is you have to be able to humble yourself and acknowledge your mistakes. I don't care if you're an amazing parent or if you've been a crappy parent. If you go into court and you say, hey, look, I've screwed up and I'm trying to get myself out of it, and the courts really respect that. I mean, it has to be real. It can't just be like, fodder, but that's, anyway, and Bree will not do that. So
thanks.
Anyway.
I agree with you 100%.
But yeah, I mean that a judge really respects when a person comes in and they're like, wow, this was a mistake and I made the wrong choice and I've learned from that. And I will never do that again because I don't ever want to be in this position again, So, and that goes a long way. And then if you can support that with therapeutic intervention and with, like you said, providing UAs or a hair follicle, they're not that expensive. They're like, you can get a hair follicle for like $400, $500.
Yeah.
I think
she's putting up stuff just like this. She just posted this the other day. It says, you were meant to be in Hawaii. She says, I'm going to steal all my kids and move there. Bye. Can you imagine posting this onto social media when you're fighting for custody and you have an anti-kidnap order? Like, the judge is not going to take her seriously when she's still doing shit like this.
I don't think she's really fighting for custody.
Right, I don't either. But can you imagine being her, like if you were her attorney and she has the orders that she has, and you get this sent to you, or John's attorney sends this to you. What are you saying? Well, this is an older picture. This is when she was in Hawaii and she found out the first time. She just reposted. I don't know, but can you imagine like what you would do if your client's posting that with everything she has going on? Oh my God.
No, I wouldn't. And I empathize with like parents who want to, I'm doing air quotes, but you can't see me, tell their story.
Yeah.
But you just can't do it when you're in active litigation.
Yeah, that's what gets me. So crazy.
Yeah. But anyway, well, thank you for letting me pop up.
Yes, thanks for coming up.
This got me because she's gonna have to provide everything. So I don't know why even do this. And then to assert that John is the one that's forcing a hearing, that's ridiculous.
Right.
She probably could have provided half the documents and they wouldn't have filed a motion to compel.
Right. At least something, like anything. Something.
Make an effort.
Right. Yeah. Crazy. All right, Love Bug. Thank you so much for coming up. I so appreciate it, as always.
All righty. I don't know how to get down.
I got you. Here you go. Okay. All right, see ya. Bye. As always, shout out to AA Law Talk. Absolutely love that we have her as part of the SOC gang, and we get a chance to hear from a current practicing family law attorney in California and give us her opinions and takes on all of this stuff. It's just crazy that filing all of these documents. Yeah, waste of money. Yeah, it's just crazy. Absolutely crazy. So, I don't know. Yep, I'm actually just getting ready to get off because I am starving. I have not eaten today. Well, I ate a little bit early this morning, but I am starving. So I'm feeling lightheaded. So I'm going to hop off. I will start downloading this right now, though. So this will be up on my YT. Hopefully, TikTok is behaving itself. It hasn't been. But hopefully it's behaving itself and it won't be skipping. Because yesterday's is not skipping. But the first one, hold on, let me pin this. You guys, I'm going to pin Betty's new page. Make sure you guys follow Betty's new page. We got to get her numbers back up so we can start doing some lives and stuff together. She lost her other page because Ashley anyways. Let me not lose mine. So make sure you guys follow Betty's new page, please, if you're not already. But yeah, so yesterday's was not skipping. I even tried to re-download the one from the day before, and it skipped again. I watched it before I put it up, and it was skipping again. So, and real quick, can you repeat what did Bree say about W's medical? All she really said is she was just alluding to something. She's like, you guys make sure you're a good parent like me and always advocating for your child's health because because I just had a daughter. Oh my God, I just had a doctor solidify my thoughts were true. That's what she said. So she didn't really say anything in particular. She was just implying that she had done something, I guess. I don't know what she's implying. So, all right, I will see you guys tomorrow. Have a good night. I love you all so much. Thanks for being here. Same time, same place tomorrow. Good night.